Hi, this is personal injury attorney and Philadelphia accident attorney Gary Heslin, and today we're going to be talking a bit about trip and slip and fall accidents. Now, one of the common misconceptions I see among the public with regard to slip or trip and fall injuries on someone else's property is that they believe that simply by virtue of the fact that you fell on someone's property, that person or company is responsible for your accident. And that's not true, and I just want to go over some of that. First of all, there has to be a defect. In other words, there has to be something that would be called an unreasonably dangerous condition. Now, that's usually pretty simple to determine. For instance, the crack in the sidewalk. Pretty simple to determine that's an unusually dangerous condition for which a landlord or a owner of a business or a property owner would be responsible for fixing. Something that might be less obvious with regard to a slip and fall or a trip and fall might be, for instance, the type of steps that someone was walking on. Unknown to many people, there are certain codes that are required when constructing or building steps in both private and commercial properties. And in the past, I've been successful in cases where a client, for one reason or another, tripped and fell, injuring him or herself while walking down steps, and the code that was required in order to construct the steps was not met, and this was a defect for which the owner of the property was responsible. So that's the first thing that is necessary for a trip or slip and fall case, that there must be a defect in the property. The second aspect of the case is that this defect must have either been placed there by the owner of the property or one of his or her employees, or that the defect was present for a period of time long enough so that the owner of the property would have been able to find or inspect and find the defect and had an opportunity to repair the defect. An example of this situation with regard to notice would be a slip and fall on water in a supermarket. So for instance, say that you're walking in a supermarket and you slip and fall on water. If we can prove by virtue of videotape or some other type of evidence that an employee of the store spilled the water, then we have a case against the store for that spill. And if we can't prove that an employee of the store spilled the water, then we need to prove that the store owner was aware of, or with reasonable inspection could have been aware of, this water on the floor and had an opportunity to clean it up. Very often this is difficult, if not impossible, to prove. So what if, for instance, about 30 seconds before the fall, another customer was walking in the store and they spilled the water? Well, in that instance, the store would not have had an opportunity to even know that the water was there, let alone clean it up. And the owner of a store is not absolutely responsible for any falls. In that particular case, the store would not be responsible, since it would have been the person who spilled the water that would be responsible. And technically, you might have a case against that person if you could locate them, which you probably can't, and if they had homeowners insurance, which they may or may not. So that's two aspects of the case. First, there must be a defect, and secondly, this defect must be such that it was either caused by the owner of the property, or that the owner of the property had an opportunity to know with inspection that this defect was there, and then an opportunity to repair it. Now, the third aspect of a trip or slip and fall case goes to the person who was injured, and the question is whether or not they should have noticed this defect. The law basically says that yes, if there's a defect and the owner had an opportunity to fix this defect, they should do it and they can be held responsible. But there's another test that has to be met: is there a reason why you did not see this defect? And if you had seen this defect, would you have been able to avoid the fall? The typical example of that would be a daylight trip and fall. If there was a large defect or a large rubble in the middle of a sidewalk, in the middle of a nice, clear, sunny day, and you were walking down that sidewalk and tripped, the law is going to want to know why you didn't see that defect. Now, there may be a legitimate explanation, but if there is no explanation, or your explanation is simply, I wasn't paying attention and I fell over it, then the homeowner is not going to be responsible for the accident. The law is going to shift the blame from the homeowner to you for basically not paying attention at the time that you fell. Now, this is just an example of some of the many issues that you deal with in any trip or slip and fall case. And these are the issues which we've been dealing with for over 30 years. If you have any questions, please don't hesitate to call us at 215-332-0300 or go online at theheslinlawfirm.com. Thank you.